We are thrilled to have the next webinar in our series about the Pregnant Workers Fairness Act and the PUMP Act. Today we'll be discussing the Pregnant Workers Fairness Act beyond the basics. We are thrilled to have this group with us today. This is the third in our series. I encourage you to go back and look at our previous introductory webinars. I'm going to go ahead and just do some early housekeeping. If you're asking questions, please do so in the Q&A section. If you have technical questions, you can put them in the chat. If you have substantive questions, please put them in Q&A. There will be some polls to be on the lookout for CLE purposes that will pop up and prompt you to answer. Also, I wanted to let everyone know that this will not be the last in our series. As more EEOC regs come out, as litigation continues with the Pregnant Workers Fairness Act, we're going to be inviting our experts back to share more with our practitioners. I'd like to take a second to thank our experts so much for being here. They're an incredible group. They've really gone above and beyond in helping ensure that NELA members have the latest and greatest information about this groundbreaking legislation. Our first speaker is Jennifer Liu, who's a partner of Katz Banking Human. She joined the firm in 2023 and works out of the California office. Jennifer is a nationally recognized litigator in employment discrimination and wage and hour class actions, and represents individuals in litigation and negotiations in all areas of employment law. Liz Morris is the Deputy Director of the Center for WorkLife Law, which is an advocacy and research center that builds legal rights in employment and education for family caregivers struggling to take care of their loved ones while making ends meet. Liz's writing on pregnancy and motherhood discrimination has been published in the New York Times, the LA Times, the Harvard Business Review, and Slate. And finally, Jillian Thomas, who's a senior staff attorney with the American Civil Liberties Union Women's Rights Project, where she specializes in employment law. She's the author of Because of Sex, One Law, 10 Cases, and 50 Years to Change Americans' Women's Lives at Work, and has written extensively about pregnancy discrimination, including in the Yale Journal of Law and Feminism and Harvard Law and Policy Review. So as you can see, we're extremely lucky to have them with us today. I am going to be hopping off camera and I'm going to turn it over to our incredible presenters.
Well, thank you so much, Ashley. Thanks to you and to NELA for co-sponsoring this series with us. We and the Center for WorkLife Law launched this initiative to meet the historic moment offered by enactment, finally, after a full decade of advocacy of the Pregnant Workers Fairness Act, the first federal statute in 45 years to protect the workplace rights of pregnant people. And as Ashley noted, our first webinar in this series last spring focused on the basics of the PWFA, its major provisions. And today we take a deeper dive, chiefly looking at the practical considerations that will enable you and your clients to actually take advantage of the extraordinary new protections in this statute, as well as be on the lookout for some roadblocks, which sadly there likely will be. Before I turn it over to Liz to start the substantive portion of our presentation, a couple housekeeping matters from me. Just wanted to draw your attention to the materials that were circulated to you earlier today. It includes not only the slides that we're going to be showing you in this presentation, but also a paper that we co-authored along with some other folks from the Center for WorkLife Law and from Katz Banks Human. And we also include in those materials a hypothetical as well as an sample EEOC charge built off of that hypothetical. And finally, some invaluable materials from the Center for WorkLife Law about common pregnancy-related limitations and accommodations that may be suitable to address those limitations. Finally, vis-a-vis questions, we will do our very best to be answering them throughout the presentation in real time. We also are reserving 20 minutes at the end of the presentation. Hopefully we don't go over and eat into that time with our substance. And then to the extent we're not able to get to your questions, our contact information is going to be provided at the end of the session, and we welcome your reaching out to us individually with any questions you may have. We want to be resources in an ongoing way in this conversation with NELA members and others around the country who are working on behalf of workers. And with that, I'm going to turn the presentation over to Liz. Oh, sorry, I forgot our agenda for the day. That's important. We're going to start with what conditions are entitled to accommodation. We'll then be moving on to what accommodations are available, then practical considerations in securing accommodations, navigating the interactive process to achieve the best outcome, responding to retaliation by employers, and then finally, as I mentioned, Q&A. So now I will turn it over to Liz Morris from the Center for WorkLife Law.
Thank you, Jillian. So I'm Liz Morris. I'm the Deputy Director at the Center for WorkLife Law. We're a research and advocacy organization that is housed at the University of California College of the Law in San Francisco. Going to kick us off with what conditions are actually entitled to accommodations under the Pregnant Workers Fairness Act. So pregnancy, childbirth, or related medical conditions is an established term that's taken from the PDA context, and it's broadly defined. It includes current, past, and potential pregnancies, childbirth and labor, symptoms of pregnancy and childbirth, which anyone who's been pregnant can tell you there are many potential symptoms of pregnancy and childbirth. Fatigue, nausea, vomiting, back and pelvic pain, swelling of the hands, feet, legs, fingers, frequent urination, loss of balance, and the list goes on. Complications of pregnancy and childbirth are also, of course, covered. So that can be things like gestational diabetes, preeclampsia, chronic migraines, ectopic pregnancies, preterm labor, cesarean wound infections, antenatal or postpartum depression, anxiety, or psychosis. Also, pre-existing conditions exacerbated by pregnancy and childbirth are covered. So conditions like depression or carpal tunnel syndrome or diabetes or high blood pressure may be made worse or different because of pregnancy in terms of what the needs are in the workplace. Pregnancy termination, so miscarriage, stillbirth, and abortion are considered medical conditions related to pregnancy. There was incredible opposition, not surprisingly, to the inclusion of abortion in the regulations, in the proposed regulations that the EEOC put out. However, the agency, the EEOC, and courts have long interpreted this term, which, as I mentioned, is taken from the Pregnancy Discrimination Act, to include abortion. So we do expect that abortion is going to appear in the final rule when it is issued, probably later this month. And we also expect that inclusion will be subsequently challenged in court. There were thousands of comments submitted on the proposed rule that focused on the abortion issue, opposing the inclusion of abortion. Now, of course, I just want to note there are separate questions related to religious employers when it comes to abortion. But of course, that's sort of a whole separate area of examination. Lactation and related conditions are also constitute pregnancy, childbirth, or related medical conditions. So, of course, break time and space is what most lactating workers need in the workplace, but there are other related conditions like low milk supply, engorgement, plugged ducts, mastitis, fungal infections, etc. Also, some may be surprised to learn that pregnancy, childbirth, and related medical conditions includes infertility and fertility treatments, as well as the use of birth control, and also menstrual cycles and changes in hormone levels. So there's the question then, what about inclusion of perimenopause and menopause? This has been a growing area of attention. Many of you probably know on the part of the EEOC, from gender justice advocates, from corporate employers. And menstrual cycles, you see there, changes in hormone levels could, of course, reasonably be interpreted to include menopause and perimenopause, and that's how we interpret it. We have asked the EEOC in our comments, and when I say our, many organizations, the Center for Work-Life Law, the ACLU, and many others, to explicitly include menopause. There's scant case law on the topic from the PDA context, and the case law that does exist, sort of, there are cases coming out both ways around its inclusion. Okay, so now we know what is meant by pregnancy, childbirth, or related medical conditions. It's quite broad. And so what are those pregnancy-related limitations that are related to pregnancy that are entitled to accommodation? So a limitation is an impediment or a problem. No particular level of severity is required. And in fact, the limitation can be modest, minor, or episodic. So most of you know that's a huge departure from what employers are used to in the Americans with Disabilities Act context, where cases are often thrown out because the condition isn't sufficiently limiting or long-lasting to constitute a disability under that law. So want to be paying close attention to the fact that even minor impediments or problems rise to the level of entitling somebody to the level of a limitation entitling somebody to an accommodation under the PWFA. A limitation can also be a need or a problem related to maintaining the employee's health or the health of their pregnancy. And this includes avoiding increased risk and pain. So there's an emphasis on these sort of preventative steps or accommodations that promote health. And that's in some ways, that emphasis is also in some ways different than the ADA. And in fact, it's really a key legislative purpose of the Pregnant Workers Fairness Act to promote the health of the employee and their pregnancy. So for example, that may include limiting exposure to pesticides or to secondhand smoke during pregnancy. It may include avoiding activities that cause increased pelvic pain or back pain or fatigue. And a pregnancy-related limitation also includes seeking healthcare, which of course is critical to maintaining a healthy pregnancy. So you get the picture here that there's very much this sort of health promotion, healthy pregnancy goals, in addition to the equal employment opportunity goals of the statute, and important to always keep that in mind. Okay. So now that we have discussed what types of conditions and limitations are entitled to accommodation, let's shift to what types of accommodations are available. Excuse me. So a reasonable accommodation, as we generally understand it to be from other contexts, is a change to the application process, the work environment, or when, where, or how the work gets done to allow the pregnant employee to do their job on equal footing with other employees who are not pregnant. And again, remember that this includes changes to protect the employee and pregnancy health. So reasonable accommodation has the same meaning as under the ADA, but there are a few key differences to be aware of. First of all, and this is huge, under the PWFA, this temporary suspension of one or more of the essential functions of the job can be a reasonable accommodation, unlike in the ADA context. This is new and big, so we're going to spend some time in a few minutes talking more about this. The definition of reasonable accommodation also in the proposed regulations, the EEOC has really elevated and dealt in detail with leave for childbirth, highlighting how important that form of accommodation is in achieving the statutory purpose here. And then finally, the proposed regs incorporate examples of accommodations that are recognized by the EEOC in the ADA context, but that aren't explicitly included in the ADA regulations. And so none of these things will come as a surprise. Oops. Let's see what's going on here. None of these things will come as a surprise. They're all accommodations that we're used to hearing about in the ADA context, but it's important to note because case law interpreting the ADA regulations may be off with regard to some of the things that the EEOC is very likely going to include in its final regulations. And also, these PWFA regulations can be used when they're finalized in the ADA context, because the definition of what is a reasonable accommodation is the same in both contexts. Okay, so here's some examples of things that folks need during pregnancy. Extra breaks for rest, snacks, water, and restroom use. This is common, and note that this goes primarily to the health promotion goals of the statute. Uniform changes, obviously the body's changing a lot in a short period of time. Changes to job duties, work location, or other modifications that are needed to reduce or avoid bending, lifting, climbing, walking, and or standing. So that could be, for example, permission to sit on a chair while someone's doing their work instead of standing, or perhaps moving the workstation closer to the bathroom. Both of those are flagged as something that the employee in the hypothetical that we have shared. Is everything? I heard somebody come off of mute. Are you? Okay, I will keep going. Other accommodation examples, change in job duties, temporary reassignment, or alternate work location to avoid exposure to toxins, viruses, physically demanding work, excessive heat. Again, notice somebody may be able to do their job under these circumstances, but again, this is going to the preventative health purposes of the statute. Reserved parking spaces closer to the work area. Schedule changes, this is huge for pregnant people often, or excusal from absence and tardiness control policies, so-called no-fault policies for late arrivals due to pregnancy, illness, or fatigue, to avoid long work hours, or to be temporarily excused from night shifts. Time off for regular prenatal care appointments, fertility treatment, and or pregnancy loss or abortion. Leave prior to childbirth and after birth for physical recovery. Often in the US, healthcare providers and other government entities accept 6 to 8 weeks as the standard time for recovery from childbirth, depending on the method of delivery. But of course, somebody who has complications or postpartum depression may need longer. Break time in private space to express breast milk or other modifications for lactation and related complications. Want to flag in your materials the Center for WorkLife Law's document that provides the types of accommodations that may be responsive for a range of physical conditions as well as a range of workplace hazards. Please check that out when you're brainstorming with your clients what may be appropriate to meet their needs. Okay, want to talk now about temporary suspension of essential functions. As I said, this is a huge departure from the ADA, so I'm going to spend a few minutes now sharing about it. Okay, so taking a step back, let's think about the definition of essential functions from the ADA, which is the same in the context of the Pregnant Workers Fairness Act. Essential functions are the fundamental job duties of the employment position that the individual holds or desires, excluding the marginal functions of the position. So a little bit of background from the ADA context. Most of you probably already know this, but employees are not considered qualified under the Americans with Disabilities Act and therefore are not entitled to ADA accommodations. if they are not able to perform the so-called essential functions of their job, either with or without an accommodation. So in ADA litigation, when an employee's disability prevents them from performing a particular job function, then a major question becomes whether that job function is an essential function, in which case they're not qualified for the job and aren't entitled to an accommodation, or if it is a marginal function of the job. And of course, employers argue that everything is an essential function, and their own judgment, the employer's own judgment as to what is essential, and employer drafted job descriptions are relevant considerations and often centered by courts. And along, of course, with what the person is actually doing in their job. So central to the PWFA is that the temporary inability to perform essential functions is not disqualifying. And again, that's a major departure from the ADA's definition of qualified employee and removes a major barrier that folks in the ADA context unfortunately face.
And Liz, I'm just going to pop in to mention that in addition to being a departure from the ADA, this part about temporarily suspending essential functions also is a departure from many state analogs of the PWFA that predated the passage of the Federal Act. And so I only think it's important for practitioners to know, because some states do have some case law under their previous pregnancy reasonable accommodation statutes, and those will not necessarily be binding on PWFA cases, because the PWFA in some ways expands the definition of who qualifies and for protections under the statute.
Yeah, that's an excellent point. Thank you so much, Jen. This really can't overstate how huge of an advancement this is. Okay. So under the PWFA, an employee is still qualified for their job, even if they can't perform this essential functions, if three prongs are met. First, the inability to perform the essential functions has to be for a temporary period. Temporary period is taken from the statute itself. In its proposed regs, the EEOC says that means not permanent. Second, the essential functions could be performed in the near future. Near future also taken from the statute. And the EEOC says that near future means 40 weeks, which of course is the normal gestational period. And that the clock starts again after childbirth. So 40 weeks during pregnancy, and then 40 weeks after the person returns from their leave. Now, the question of the meaning of near future is one area where the EEOC asked for feedback and raised specific questions about that timeline and whether it should restart. And so that indicates that the EEOC is still considering what is the appropriate standard here. I think that the conclusions that they reached and put forth in the proposed regulations are excellent and also necessary for achieving the statutory purpose here. But this is an area where we'll be paying close attention when those final regs do come out. And then finally, an employee is still found qualified even if they can't perform the essential functions, if the inability to perform the essential functions can be reasonably accommodated. And the EEOC has pointed out that that in its proposed regs that may be through the temporary suspension of the function. In other words, nobody's doing it. It may be through reassignment or coworker assistance with performing that essential function. Just a few notes on essential function removal. First of all, employers are still pretty confused about this, so be on the lookout for that. There on WorkLife Law's free legal helpline, we're seeing employers really still centering this question around essential functions. Also want to point out that the ADA case law on essential functions is still relevant, because we do want to show that particular removed job duties are not essential, so that we don't have to go through these three prongs and argue about near future. So for the moment, we would recommend using sort of in the alternative argument that these functions are not essential. And if they were found to be essential, these three prongs are met, and they can be performed in the near future. And removing them can be reasonably accommodated. And you'll see that was set up in the model EEOC charge in your materials. Also want to point out that the proposed regulation emphasizes that the most important consideration in determining whether something is an essential function is whether the employee in the position is actually performing that function. So employer judgment is still relevant, but the proposed regulations, at least, were strong on the point that courts should really be looking at what is the employee doing. And so that's helpful, obviously, in the PWFA context, but I think it's also going to be useful, assuming it's in the final regs, in the ADA context as well, in pushing back on some of that judge-created law that very much focuses on employer beliefs and gives discretion to the employer to determine what is essential. Jen, Jillian, anything to add on that? This is just such an exciting area. Okay, hearing nothing, I will move on. Okay. Want to spend a few minutes talking about leave as a reasonable accommodation. As I said, it is so central to the Pregnant Workers Fairness Act, and the EEOC has treated it as such in its proposed regulations. So access to job protected time off is an important legislative goal. And that includes full-time leave, intermittent time off, and part-time schedules. Unpaid job protected leave and using accrued paid leave are reasonable accommodations for childbirth, medical appointments, pregnancy-related illness. So that could be somebody who has morning sickness and needs time off, as well as recovery from pregnancy termination or loss. The EEOC has made clear that employer concerns about length, frequency, or the unpredictable nature of requested leave are questions of undue hardship. And that's really important because we've seen in the ADA context some courts not treating that as a question of undue hardship and dealing with it earlier on as an essential, attendance as essential job function and so on. So this is very helpful guidance both for the PWFA as well as for the ADA. Okay, so I think the big question here is, well, what is an acceptable duration for time off? The guidance from the EEOC is understandably scarce. It's a fact-specific situation or inquiry when we're thinking about undue hardship. Every workplace is different, every situation is different, but the proposed regs do give us some indication. In the appendix, there are many super helpful examples from the agency, and some of them discuss folks or hypothetical employees who are on leave. So in one example, the employee needs 6 to 8 weeks off to recover from childbirth, and the agency concludes in the hypothetical that the employer must provide the leave absent undue hardship. In another example, the EEOC finds that an employer has to adjust the employee's performance quota to account for a 4-month leave. And then finally, there's an example where an employee is entitled to 10 days off to recover from a miscarriage, despite that they are a new employee who is not eligible for FMLA. All right, here just a few lessons from the ADA regarding leave as an accommodation. I have a couple of things I want to point out and then encourage you, Jen and Jillian, if you have any lessons that you'd like to share with people about securing leave. I think folks would love to hear that. In the ADA context, Findings regarding duration of leave vary from case to case, and some are not good. There are some cases where courts have found or have approved leave of multiple months or even longer, particularly when those longer leaves are tied to an employer's own policy. And so the tip is to seek evidence of no undue hardship in the employer's own handbook, because many provide unpaid personal leaves of 6 months or a year at the employer's discretions. And thank you to my colleague Cynthia Calvert for this tip. The second is to advise clients to request a finite amount of time by providing a probable end date for their leave, even if they have to go back and modify it later. Courts are very resistant to leave that is indefinite. And so even if the date has to be changed later, always advise your client to provide the probable end date, or their healthcare provider to provide the probable end date for the leave so that it will be found to not impose an undue hardship. Just going to pause for 1 second if Jen or Jillian has anything to add.
Well, I wanted to jump in because we have a question actually in the chat that I think sort of overlaps with this, Liz. And the question was about if someone needs 6 to 8 weeks off to recover from childbirth, does that have to be taken concurrently with FMLA? And I think the answer is that it depends on what the employer's policy is with respect to other leave as an accommodation, for instance, for disability. But correct me if I'm wrong, but I think the main issue is that even if the FMLA is exhausted or the person isn't eligible yet for FMLA, that time off is still appropriate.
Yeah, so the way, and I want to know what Jen thinks as well, but the way that I would think about that is that if the employer wants to run the FMLA clock, then the employer is entitled to run the FMLA clock while somebody is on leave under the Pregnant Workers Fairness Act. So it's not like they can sort of stack those leaves. I have 6 to 8 weeks here, and then I have 12 weeks. I don't think, and perhaps the person who asked that's from California, where we have something like that under the pregnancy discrimination, or the pregnancy disability leave law. I don't think that is the case here. The employer can run their FMLA clock, but as Jillian noted, if somebody is being treated differently than other employees where, the employer isn't running the FMLA clock for other folks who are taking FMLA qualifying leave, then that would be an issue of retaliation under the PWFA and discrimination under the Pregnancy Discrimination Act.
And
Okay. Go.
I just add, I agree, Liz, and I think it's also important, and many people may understand this already, but the 6 to 8 weeks is guidance that's tied to what is commonly needed by people post childbirth. It's not a strict allotment like it is under the FMLA. And so I can imagine many cases in which a reasonable accommodation might be quite a bit longer than 6 to 8 weeks if somebody is experiencing postpartum depression or some other kind of medical complication or other limitation. And so, I think that is in some senses effectively a floor. The other thing I'd say is, in terms of seeking evidence to support leave as an accommodation, the other thing to look for, other than the handbook and company policies, is also just to look at comparators. If there are other people who have taken longer leaves, those could be used as evidence of why it's not an undue hardship. Sabbatical policies are another example. And if there are workplaces that either on an ad hoc or on a consistent basis are allowing people to take these longer leaves, even if it's not in a handbook, I think that can be persuasive.
Absolutely. Thank you. Such great points, Jen. Also want to encourage people to check out Brian East's Union Member Guide to Labor Law, which is cited in our CLE materials. because he's collected cases there finding months-long leave to be reasonable under the Americans with Disabilities Act. Okay, practical considerations regarding leave and time off. Typically, leave is unpaid, which makes it often inaccessible, of course, especially to the lowest paid workers. However, several states provide temporary disability insurance or paid family and medical leave programs where income replacement may be available not only following childbirth, but also while somebody is still pregnant when they are unable to work because of their pregnancy. So such programs that provide TDI and PFL can be found in California, Colorado, Connecticut, DC, Delaware, Massachusetts, Maryland, Maine, Minnesota, New Jersey, New York, Oregon, Rhode Island, and Washington. And some employees have private short-term disability plans. Consider those in situations where somebody is unable to work because of their pregnancy. The EEOC in its proposed regulations has said, same as under the Americans with Disabilities Act, that the PWFA does not require continuation of health insurance benefits unless continuation of benefits is offered to employees in a similar leave status. So this is a reason why you maybe would want the FMLA clock to be running. Not the EEOC, the Center for WorkLife Law, and several other organizations urged the EEOC in our comments to change this from sort of a comparative standard to a question of undue hardship. But given that this is how the law has been interpreted under the Americans with Disabilities Act, and this is what the EEOC laid out in the proposed regulations, I think we do need to be prepared to conduct this comparative analysis where we want to demonstrate that employees who are in similar leave statuses have their health insurance benefits continued, because health insurance benefits, I think, to state the obvious, are absolutely critical to somebody during their pregnancy and immediately after childbirth. And so I think that folks who are on FMLA leave are an obvious comparator for, that, and we will want to make the case that they are in a similar leave status. Also want to note that the paper that's included in your materials has some other practical considerations regarding leave and time off. Touching on remote work as a reasonable accommodation, remote work can be super helpful to people during pregnancy and during breastfeeding and chest feeding. And of course, our conceptions around remote work have changed because of the pandemic. So the proposed regs include telework as an example of an accommodation for a period of bed rest, a mobility impairment, nausea and vomiting, and significant fatigue. Also, on our legal helpline at WorkLife Law, we consider remote work for mental health issues, for concerns about exposure to COVID in crowded workplaces, and challenges pumping milk while an employee who has challenges pumping milk while they're away from their infant during the workday. Of course, not every job can be done remotely. So when full-time telework isn't possible, consider part-time telework or suspension of job duties that require in-person attendance. And check out our paper for more on remote work. Accommodations for breastfeeding, chest feeding, and lactation. The primary accommodation that folks need who are lactating is break time and private space for pumping milk. We have a webinar on the Pump Act, which I hope you all have heard of by now, a new law that gives a right to break time and space that was signed in at the same time as the PWFA. Encourage you all, it's the second webinar in this series, to check it out. It's available online. You can use the PWFA to supplement the Pump Act. The primary time when this may be needed is when somebody needs break time and space for longer than 1 year, which is what they're entitled to under the PUMP Act. Also want to note that there are other accommodations that may be needed by lactating workers. So perhaps avoiding exposure to toxins that can contaminate breast milk, like pesticides, uniform changes, time off for lactation related appointments, working from home for direct nursing in the case where somebody can't express breast milk. And I also want to flag, because we see this all the time on our helpline, and I find it really irksome, is that employees who don't want to pump in private spaces aren't, the employer is nothing in the PUMP Act requires that an employer make somebody pump in a private space. It's only that the employer make the private space available to the employee. And many employees don't want to pump in a private space. You know, maybe claustrophobia comes up for some people, but mostly because they want to get their job done, because they're either committed to their job and don't want to be taken off of the clock. And so when an employee wants to continue, you know, working, so, you know, pumping at their desk, or perhaps, you know, in the lobby of their building, employers, there's nothing in the PUMP Act that prohibits that. And it may be that employers are required to provide that as an accommodation under the Pregnant Workers Fairness Act. And not doing so would be not only a violation of the PWFA, but also could be a violation of the Pregnancy Discrimination Act, when other employees are being allowed to, you know, attend to their personal health needs and at their desk or in the lobby or, you know, the public spaces. So keep an eye out for that, because we see that all the time. And there's significant implications when people are taken off the clock when they're able to continue pumping and working. Okay, I am going to pass the baton now back to Jillian.
Thanks, Liz. So I'm going to be talking now about, now that we've had this terrific overview of exactly what kinds of accommodations might be necessary and available, I'm going to talk about how do we go about getting them for our clients? How do we secure them? If you go to the next slide, please, Liz, the overarching issues that I'm just going to talk about here for a couple minutes are, first of all, the good faith defense that is available to employers, making known your client's limitation, and finally, interactive process stumbling blocks. That'll be the bulk of my presentation. On the good faith affirmative defense, I'm sorry, I should be specific here. The likely stumbling blocks we'll be talking about in a couple minutes. First of all, Liz has alluded to it, but employers really are confused about the implications of PWFA for and the interactions with the ADA, FMLA, and state and local statutes. And a lot of employers are simply shoehorning pregnant workers or workers affected by pregnancy into existing procedures for ADA accommodations and otherwise imposing the same eligibility requirements, which, as you've already heard, there are quite a few important distinctions, and you're going to hear more about them as we go through the interactive process. So this has resulted in tremendous delay for workers needing accommodation, and of course there is an inherent time limitation on a pregnancy and a pregnancy-related accommodation, and so delay by employers can have truly devastating consequences for health and economic security. And we'll, if I have time, we'll touch on the fact that a larger number of people affected by pregnancy seeking accommodation means a larger number of opportunities for bias and other kinds of resistance to be raised by employers and coworkers. So we'll talk a bit, hopefully, about addressing those issues and arming your clients against them. So going to our next slide, just really briefly wanted to touch on the good faith affirmative defense. So to be clear, this is not a defense to liability. It is a defense to damages, and it's also in place in ADA failure to accommodate cases. The employer bears the burden of proving it. It's not been defined in the PWFA by Congress, nor in the draft regulations by the EEOC. And from the ADA context, we don't have any hard and fast rules about what an employer has to show with respect to having made good faith efforts. But it has to, there are a few general categories of findings from the courts. The employer's effort to accommodate has to have been more than just lip service, maintaining a policy and a handbook somewhere that doesn't really actually play out in practice. No meaningful interactive process in terms of a real genuine back and forth that's aimed at problem solving, and then imposing undue delay in the interactive process is also likely going to doom a good faith affirmative defense. So again, not a defense to liability, but do always have it in the back of your mind as the interactive process negotiation is going on, because while you may prevail on liability with failure to accommodate, it would be a shame to have the employer have grounds for saying, yes, but we're not required to pay compensatory and/or punitive damages because we just really did our best. So to keep that in mind when we're thinking about making the record through the interactive process, and that is very much your mantra in the interactive process, is making the record. Okay, moving on to the question of assuring that your client's limitation, which we've talked about in depth already, is actually known to the employer, that the employer is on notice that there is a limitation. And it's defined in the regulations as having been having communicated both the limitation and the need for some modification in the workplace. And note that even a representative of the worker, as well as an applicant, can be the one to communicate this to the employer. Very significantly, the EEOC in the model, or excuse me, in the proposed regulations has made explicit that no quote unquote magic words are required. In other words, the worker is not required to use legalese or come to their supervisor and say, I have a known limitation, or I have a limitation caused by pregnancy, childbirth, or related medical conditions that requires reasonable accommodation. That kind of formulaic request is not required. And the proposed interpretive guidance that's an appendix to the regulations that Liz has alluded to a few times it contains a wealth of scenarios illustrating these various principles, including this no magic words requirement. And the sample EEOC charge, by the way, hypothetical and EEOC charge that we included in your materials represents this situation in spades. An employee who repeatedly alerts the employer of a limitation and a need for modification that went ignored. Significantly, and this is important to remember where employers get really stuck on their ADA processes, and oral communication about the limitation is sufficient to kick off the interactive process. The employer cannot require that the communication be put in writing before they're going to take any action on it. They may have some additional certification requirements, which we'll get to momentarily, but the oral communication about the limitation and need for modification is what is supposed to get the ball rolling on the interactive process. Again, speed is of the essence here because of the nature of pregnancy. And then on our next slide, a few more things to be aware of in making the limitation known is to be really clear. So notwithstanding what I just said about what the EEOC recognizes as being sufficient to put the employer on notice, if your client can be explicit, that is preferable. And also it's even more preferable if they can propose an initial accommodation or accommodations. So that's always a really terrific way and frankly best practice for informing the employer of what your limitation is. If you're also saying, here are the things I can do safely, you're sort of killing two birds with one stone in terms of the information that you're conveying. Additionally, you want to, as always, be sure that there's a record of having put the employer on notice. Again, oral communications are sufficient, but it's always ideal for purposes of potential future litigation and debunking the good faith defense that if the client has, for instance, taken notes of a conversation, that they take a photograph of those notes and send them to themselves. So they're date and time stamped, and similarly to confirm conversations in emails, not just to the supervisor, for instance, to whom the information was conveyed, but also to HR. Again, it might be something that only happens after you're in the picture, but if you're behind the scenes advising a client, this is really critical. Make that notice provision explicit.
I'd like to also add another practitioner point, if I can, which is that oftentimes those of us who counsel pregnant employees about when to tell the employer that they are pregnant, there's this custom and norm that many people don't tell people about their pregnancy for the first trimester. But of course, the first trimester is also the time when so many people experience really disabling symptoms. And I do think that, I think about, with this law, I think I will actually change how I advise people. Whereas, before, I might have thought that there was some benefit to not disclosing a pregnancy at the earliest possible time. I think here, because there are so many protections provided by the PWFA that employees are not entitled to unless they make it known and communicate it, that there really is, I think, a much stronger incentive to to notify the employer of the pregnancy as early as the employee is comfortable. The other issue that I think might be worth advising clients to do is if they are notifying the employer early, to ask the employer to keep the information private and not tell people, because we all know that sometimes people don't know what the legal framework is, and will be very excited for the employee perhaps and want to tell people, throw a baby shower. That information is private. And while the PWFA does not explicitly prohibit the disclosure of that medical information, the ADA does. And so even though it is illegal to share that information, clients are probably really well advised to remind the employer that they don't want this information shared until they are ready to share it with people beyond the employer.
Great points. Absolutely. Okay, so moving on to the interactive process, which is really where the work is getting done here to actually identify the accommodation that your client needs. I wanted to actually start with undue hardship, because it's just important to have this in mind. This is the ultimate defense that the employer has, right? That this law requires reasonable accommodations of known limitations unless undue hardship can be shown. And so when you're thinking about making that record that we've been talking about, this is what we want the employer to be making the record of and proving and showing that that it's actually an undue hardship, as opposed to sort of generalized claims, oh, that would be too difficult for us to do. And so the proposed regs define undue hardship in the same way that it's defined under the ADA. and it's significant difficulty or expense incurred by a covered entity in light of the factors set forth in paragraph J2. Paragraph J2 has a number of factors that in the interest of time, am not going to read through all of them. You've been given it's both in our paper and you've been given the PowerPoint. But again, have this in your mind as you go forward in all of the negotiations, that unless it's an undue hardship, your client should be getting the reasonable accommodation they need. Can we go to the next slide, please? Predictable assessments, Liz alluded to these in her presentation. This is a real departure from the ADA, where the EEOC has specified in the regs that there are certain common conditions of pregnancy or needs of pregnant people that they consider so routine and so de minimis that they will virtually always be found not to impose undue hardship. And there are 4 of them. Being allowed to carry water and drink as necessary, which, by the way, you might think that is a no-brainer, but some people in customer-facing roles, for instance, have been precluded from carrying a water bottle with them. Being allowed to carry and drink water, take additional restroom breaks, being allowed to sit if they usually have to stand, or stand if they usually are spending time sitting, and allowing additional breaks to eat and drink as necessary. Again, the entities and groups that have submitted comments have urged that there be other predictable assessments that are similarly pretty pro forma and so common that they should not be considered to impose undue hardship in most circumstances, and we'll see what the EEOC does with that. Okay, with those sort of preambles in mind, let's move actually to the interactive process. Once your client's limitation is known to the employer, then that process is supposed to be getting underway. And employers are likely familiar with the interactive process from the ADA, but there is so much that is both substantively and procedurally different in the PWFA context that, quite frankly, you and your client are probably going to be doing a fair bit of consciousness raising. And so it's really, really critical to have your arms around what the process is supposed to look like and what they can and can't ask for. So the process as defined in the proposed regs of the PWFA is that it's an informal interactive process that identifies the known limitation and the change or adjustment at work that's needed. If either of those things are not clear from the initial communication, and then identify potential reasonable accommodations. There are no rigid steps that must be followed. And whether you embroider that on a sampler pillow and keep it in your office, or put it on a sticky note above your mirror in the morning, no rigid steps should be your mantra going forward under the PWFA. Next slide, please. So as alluded to, the interactive and the EEOC's proposed regulations and the interpretive guidance really makes these points in sharp relief, which is that this is not supposed to be necessarily even a formal process. It's not supposed to be multiple conversations. If it's possible to have a single conversation in which a worker says, I'm really having trouble getting to work on time. I'm sick as a dog in the morning. Could I possibly come in an hour later and leave an hour later? And then the supervisor says, sure, that'll work, that we don't have that much business in the customer traffic in the morning. Boom, you've had an interactive process that has identified a reasonable accommodation, and that's totally sufficient. Some of the other, de minimis limitations that might result in very, very quick interactive processes are those involving the predictable assessments that were mentioned, but there are many, many others. The regs really do urge simplicity, flexibility, and remembering pregnancy is different. There's a temporal urgency here that means that we can't spend too much time dithering with lots of different steps and processes. However, there might be some need for additional discussions. And if so, the regulations urge a step-by-step process that the parties follow that involves looking at the job at issue and what the specific accommodation sought is. Are there other accommodations that would be suitable? And if there's an essential job function that's implicated, is that something that could be suspended temporarily, again, with the idea that it could be performed again in the near future. Note that these are mostly pieces of information that are in the employer's hands, knowing what other jobs might be available in different facilities, or vacant jobs that might be available, or for instance, accommodations that have been made for other people with similar limitations. A lot of this is going to be in the employer's hands. And so for the practitioner, actually, if you could go to the next slide, please. For the practitioner, it's important to remember that there are many, many different ways to skin this cat, and to be at the ready with suggestions about what those might be for the client. And then to make those proposals to the employer, make a record of making those proposals, or if you need information in order to make proposals, ask those targeted questions, and then make the record about whether those requests were ignored or answered. And then the idea of interim accommodations is one to always have in mind, because while we hope it's going to be the no fuss, no muss conversation that I mentioned earlier, unfortunately, this process is likely to go on. Sadly, the Center for WorkLife Law and others have reported that this is an extremely common occurrence, that employers are in fact demanding extremely onerous justifications and paperwork. They're involving third-party administrators to be making decisions, and all of this takes time. Meanwhile, you have someone who's coming to work performing job duties that might be dangerous, inhaling chemicals that might be dangerous, feeling in pain because of various conditions, and that is, or staying home because they don't want to incur those dangers. And so those are really serious consequences. So while you're navigating that step-by-step process, having interim accommodations in place is critical for your clients' well-being. And yes, emphasizing at every turn in this process that this is a temporary condition, and this isn't the ADA. Okay, next slide, please. Oh, by the way, sorry, one last note on we don't need to go back, but just something to keep in mind. Again, in the interactive process, this is where that good faith defense gets triggered. So we're not just looking at liability questions here. We're also really wanting to make the record that the employer did not participate in good faith in the step-by-step process. Okay, choosing among accommodations. Sometimes there's an embarrassment of riches, and there might actually be multiple different accommodations that could serve your client that the employer identifies. As under the ADA, the employer retains the ultimate discretion to decide which accommodation is extended, but the EEOC regulations and guidance say the worker's preference should be given primary consideration. There are 3 important guardrails, though, to the employer's exercise of discretion when choosing among different accommodations. Number 1, they can't force the employee to accept an accommodation that wasn't the result of the interactive process. Second, they can't force the employee to take leave if the worker did not request leave as their accommodation, and there is another accommodation that can be provided. And finally, the accommodation must provide the employee with equal employment opportunity. Now, that's also taken from the ADA, and I think all can see that that's a rather mushy concept, that the way it's defined by the EEOC is that it's the opportunity to attain the same level of performance or to enjoy the same level of benefits and privileges of employment as are available to the average similarly situated employee without a known limitation. And if you're groaning, it's because you have lived through litigating PDA cases with comparators, and that is a real mess of an analysis to have to get into. And believe you me, the commenters on the regs pointed that out and asked for more clarity on this. That said, this is where your client comes in being the best source of information about what in the particular workplace, in the particular job. Is it a quota job? Is it something that relies on territory? For sales and so forth, your client's going to be the best source of what is equal in that particular workplace, and in identifying who's the proper comparator to point to for tethering that analysis.
Lillian,
Yeah.
can I also add that when we're thinking about choosing among accommodations, and this didn't show up in the proposed regs, and we asked the EEOC to include it in the final regs, but another consideration should be in line with the statutory intent, which accommodations are best meeting the health needs of your client. So if there's something that kind of reduces the risk, and then there's something that reduces the risk substantially, then there's an argument to be made that actually the substantial reduction is the appropriate accommodation because it's available and it doesn't impose an undue hardship.
Indeed. Yeah, no, thank you for making that point. And it's again, pointing out that that the PWFA allows people to avoid further harms and risks. It's not just like the ADA where you have to establish that you have a serious condition. PWFA accommodations can be aimed at avoiding serious conditions, which frankly is in everybody's interest in the workplace. Okay, next slide, please. And I'm very conscious of time. We want to run a little long. It's because there's so much good stuff to get to, but I'll go a little zippy here, but this is a chief area, as I've noted, where employers are really, really gumming up the works here and not understanding the distinction between the ADA and the PWFA. So requests for medical certification. The proposed regs say very clearly that an employer need not ask for certification, and in fact urges that self-certification, self-attestation from the worker is with what their doctor is telling them is the best source of information about what the person can and can't do and what they need. But if the employer wants to ask for certification, it can only do so when it is reasonable under the circumstances. And they give some examples of that. So for instance, they give some examples of what is not reasonable. So where the need for accommodation is obvious, you have someone who's in their eighth month of pregnancy and is asking for a uniform that fits, or is asking to avoid repetitive heavy lifting. Or the employee, when they first put the employer on notice of their need for accommodation, has already provided everything and everything that the employer might need, start date, end date, nature of the limitations, and so forth. We talked before about predictable assessments, those pretty minor and extremely common limitations, like carrying a water bottle or going to the bathroom more often, really shouldn't need medical certification for those. And then I think Liz mentioned this already, but with respect to lactation and pumping, the EEOC makes explicit that self-attestation is sufficient. You per se do not need to be asking for a medical certification, per se unreasonable. So even if the employer has a reasonable need for medical certification, what is permissible certification to seek? And again, it's a reasonableness standard. So it's certification or documentation that's sufficient to describe the physical or mental condition and confirm that it is indeed related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Okay, it's a PWFA qualifying condition, and confirm that a change or adjustment at work is needed. They do not need a major motion picture description of everything in your medical history or everything even about your condition that's giving rise to the need for accommodation. It's simply that there is a limitation, it's caused by pregnancy, etc., and that an adjustment at work is needed. That's what they're entitled to get. That's what's reasonable. One thing that's great that the proposed regs provide, and advocates were really happy to see, is that a wide range of providers were approved as being the folks who can give certification that will be acceptable. So it's not just doctors, it's a whole range of professionals who your client might be seeing, from doulas to midwives to physical therapists to mental health therapists. And it's a very long list that you can look at in the regs themselves. Moving on quickly to talk about delays in the interactive process, which again are chiefly caused by these onerous and unnecessary medical certification requirements. Just as an advocate for your client, I think emphasizing cooperation is key, but then also educating the employer about the consequences. You're not in ADA land anymore, you're in PWFA land. And in fact, unnecessary delay is itemized in the statute itself, not just in the regs, as being an effective denial of accommodation. So the longer you go on, the more you are effectively denying this accommodation. So educating them about that, educating them that the EEOC also has said that making repeated unreasonable requests for documentation can be deemed to constitute retaliation or coercion under the statute. And we're going to be talking in a couple minutes about that. And again, have we mentioned, this is not the ADA. While the prolonged delay is going on, emphasizing the need for an interim accommodation, the EEOC in fact says that when there's been an unreasonable delay and no interim accommodation, it's more likely to find an effective denial of accommodation. And as always, keeping a record of all of these communications and the delay, and noting the delay as it goes forward. I just want to note here before I think I'm going to stop here and hand it over to Jen so she has sufficient time. Again, the slides are in your materials, so you can see the last few darlings of mine that I'm killing in service of moving things along. But I do want to just note that in the hypothetical that we gave you an employer that really is pretty oblivious to the PWFA having been enacted, and so is basically shoehorning the pregnant worker into ADA procedures, or in fact denying accommodation altogether because that's ADA, not pregnancy. In the charge, we included allegations not just of individual violations, but class-wide allegations. And we did that because of the formalized policy that was so obviously disadvantaging pregnant workers needing accommodation. And so that's not going to be appropriate in every single case, but I did just want to note, given how oblivious many employers are showing themselves to be about the PWFA, we did want to give an example of a place where it might actually be appropriate to include class-wide allegations. So I'm gonna stop there. There's more to say on all of these topics, but I want to be sure to turn it over to Jen for her material.
Thanks, Jillian. So I'll turn next to retaliation and interference as well. And you know, in this area, I think I can make this point a little quick and leave some time for Q&A, because a lot of these concepts are familiar. So even though the PWFA is new, a lot of the considerations about retaliation and interference claims are the same as they are under the ADA, the FMLA, and the other statutes that have a similar reference to both retaliation and interference. One thing that I think is worth noting is who is protected from retaliation and interference. This is getting a little bit into the weeds, and I won't read the statutory language, but only to call out that there is 2000 GG 15 as well as 2F that are two different areas where the statute prohibits retaliation. And in the first one, 15, it prohibits employers to take an adverse action against a qualified employee for requesting or using a reasonable accommodation. And the point to make is that if you look at 2F, these are broader prohibitions that prohibit retaliation and interference with respect to any employee or any individual. And so it's not necessarily just the employee with the limitation who is requesting the accommodation. It could be a coworker who is speaking up on that person's behalf. So just be aware that it protects people even beyond the employee who has the known limitation. So moving on to the next slide. There is retaliation, and there's also the regs give a lot of examples of both retaliation and what is referred to in some places as either coercion or interference. And this is the interference language in the PWFA is almost exactly the same as the language in the ADA. The only difference is that there are references to coercion as opposed to interference, but the concepts are pretty much the same. And as with cases under the FMLA and the ADA, there are a lot of employer actions that are both. They are both retaliatory, and they are examples of interference, and those can overlap. So, for instance, if coworkers are upset with an employee for requesting an accommodation, they may start to treat that person poorly, and the employer may not respond to the employee's complaints that they're being harassed at work because they've asked for this reasonable accommodation that is perhaps putting more work on their coworkers, and that would be an example of something that is interfering with this employee's ability to use the reasonable accommodation, and it's also retaliation against the employee for exercising their right under the PWFA. So just to go through really quickly, and I won't touch on all of these, but the main kinds of retaliation cases that we're likely to see, the ones that are called out in the regulations are, of course, penalizing employees for requesting an accommodation, penalizing them for taking an accommodation. This can be an example of coworker harassment that I just mentioned. Another example of what this might look like is, for example, holding an employee's attendance against them when their reasonable accommodation is to be allowed time off of work. And so if they are holding their absences that are their accommodation against them and subjecting them to discipline, that is retaliation as well as interference. Penalizing employees for appealing the denial of a reasonable accommodation. So employee asks supervisor, can I have this accommodation? Supervisor says no. Supervisor's decision is clearly illegal. So employee goes to skip level manager or HR to say, my supervisor said no. HR says, well, of course that's wrong. Here's your accommodation. But then the supervisor holds a grudge because they were overruled by higher powers. That's another example. Of course, as Jillian mentioned, unreasonable requests for documentation. Those can be retaliatory when they're intended to penalize the employee, but even when they're not intended to penalize the employee, they can still be interference. So, for example, asking an employee who has already submitted a doctor's note and asking them, well, could you have your doctor fill out this form? That is something we see happen in ADA cases, the ADA context, where under the PWFA is clearly unnecessary and illegal unless there is a specific reason why it is necessary and reasonable under the circumstances. And intentional disclosure of medical information, which I referred to before. Okay, and there are other examples, but I'll let folks read through these on their own and save a little bit of time for Q&A. And I just have one last slide to go through, which are just some practical considerations for responding to retaliation and interference situations. And this has been said many times, but I think cannot be said enough, is to advise employees to keep contemporaneous documentation. And to be explicit about it, have them send time-stamped emails to themselves or create some sort of record of when the notes are being made. If they do handwritten notes, take a picture so it's time-stamped. And in addition to keeping records of what is happening with the accommodation request, both the request, the communications to the employer, the interactive process. The other thing that employees may want to do is to take documentation of their job performance pre and post request, because if they are anticipating experiencing retaliation, the employer is more than likely going to say, well, the reason for this change in behavior towards the employee is not because they're pregnant or because they've requested a reasonable accommodation. It's because their performance is suddenly deteriorated or their performance has always been bad. Having that documentation ready to go is oftentimes really important. Identifying potential witnesses and obtaining statements. Witness testimony is really, really useful for practitioners, as we know in these cases, when you have someone else who is supporting your client's perspective. Also, warn employees about recording their employer or obtaining documents. As we all know, the laws on recording differ state by state, and oftentimes we see people with great cases mess them up by taking an illegal recording or taking documents that they shouldn't have. And then finally, there are considerations about how do you make a complaint? To whom do you make the complaint? If you're advising someone behind the scenes, do you tell them to go to their supervisor? Do you tell them to go to HR? And I don't know that there's a one size fits all recommendation, but that is, of course, the same kind of nuanced, depends on the circumstances analysis that we attorneys do in all cases. And then, of course, proving a claim and what are the kinds of evidence that you want to be looking for. And just to emphasize again, these are the same things that we look for in all cases, that they engaged in protected activity, showing the chain of causation, and of course, keeping a record of damages, including their efforts to mitigate if they have had damages that need to be mitigated. But with that, I want to leave 7 minutes for Q&A and open it up for questions.
Well, while we wait for people to put things in the chat, I wanted to just pick up on something that Jen mentioned about potential resistance from other workers. These some of the kinds of care that people are going to be obtaining can trigger a lot of emotional responses, whether it's because your client is in a same-sex relationship and is pregnant or is undergoing IVF, and people claim to have moral or religious objections. Your client is obtaining abortion care, or because your client is seeking an accommodation for something that's perceived to be too minor or otherwise, seeking some sort of special treatment. There are all sorts of biases against pregnant workers and mothers that are well documented in the social science. And so working with your client to just be prepared for that, to maybe think about enlisting folks who could be counted on to be helpful sort of ambassadors for her as she navigates this process, preferably men if at all possible. And also to rehearse with her, some very simple kinds of comebacks, if you will, when people start giving her a hard time about the slack they're having to pick up because of her and so forth. Whether it's something like, I'm just doing what I need to do to protect my health or something like that, that's non-confrontational and factual. All of those things are helpful sort of bulwarks for your clients, emotional well-being, and then of course, as Jen said, tell the client, take notes, document, any of that kind of harassment. And then if you go to trial, maybe you need a social science expert to help explain to people exactly these kinds of deep-seated biases and why they're triggered. So while I was dancing as fast as I could there to fill time, we got some questions. Are compensatory damages allowed for retaliation claims? Courts differ under the ADA. Yes, they are available for retaliation claims. Deborah Karpatkin asks, are any of you concerned that these approaches for accommodation, et cetera, under the PWFA, which are more employee friendly than the ADA accommodation process, could lead to non-pregnant persons claiming they're being treated unfavorably? There we go. A form of reverse discrimination. Unfortunately, we've had some former EEOC commissioners making just that, or former EEOC general counsel making just that, arguing for just that point. I think my answer, I'm eager to hear what Liz and Jen have to say. I mean, my answer is sure. I'll never underestimate the power of people's biases, especially against pregnant people. The ADA has been in place for over 30 years, and yet pregnant people seeking the same kinds of accommodations have long been called asking for special treatment. I think, to the extent the protections go beyond the ADA, I think, sadly, our clients have to be educators a bit about, and of course, what really should happen is that their employers are the educators about the fact that there are myriad limitations and health consequences of this major medical event that are going to interfere with work. And the good news is it's temporary. So to just really be clear that there are good medical reasons to be taking precautions and to be doing the various things that people are asking to do to stay safe, and that everybody benefits when people are able to stay safe on the job and continue working rather than having their lives go off the rails because they, needed to take a few more bathroom breaks. But I'm eager to hear from my co-presenters about what their approach would be.
Great. It's a really interesting question. Thank you for asking it. And, I might be a little bit naive, but I'm not as concerned about reverse discrimination claims under the PWFA for a couple of reasons. It's like the ADA, you have to be a qualified employee to get a reasonable accommodation. And so if you don't fall into a protected class, or if you don't meet this definition, you're not entitled to it. And so on the other hand, there are other categories of other protected categories who are entitled to reasonable accommodation, and the one that immediately pops to mind is, of course, disability. And I am aware of at least one case or set of cases in which there was a disabled plaintiff or disabled plaintiffs that made the argument, well, if pregnant people get this benefit, then we should get it too. And I think I would worry more about this situation if we were in a world where the PWFA tracked the ADA's definition of disability, but we're not, and in that the PWFA is broader and uses a different qualification for who is entitled to it. So I think that there are cases in which there is some cross-pollination where you could say, well, if it's not an undue hardship under the PWFA, it's it's not an undue hardship under the ADA. I think that is possible. But a reverse discrimination case, I think I'm not as concerned. If men are complaining, well, we don't get these benefits because we can't become pregnant. I think the response to that is, well, this is not a gender-based classification, because not all women or people who identify as female are entitled to this either. So it's not simply based on sex or gender.
Well, I think that brings us right to time. I want to thank you guys so much for being here. Liz, Jillian, Jennifer, your expertise is really invaluable in this area, and it's been such a pleasure to have you again. And we hope to have you again earlier in the new year to talk about the EEOC regulations, which I am hopeful will be very promising. I wanted to remind everyone on the call to keep an eye out for NELA's continuing programming into the spring, including our spring seminar, which is a dual track seminar, one track on representing public employees and one on federal sector employees. We will be having a session on the updates to accommodations law, both the PWFA and the ADA at that session. And of course, our convention in Philadelphia next June. So thank you all so much for being here. Thank you, Liz. Thank you, Jennifer. Thank you, Jillian. And I hope everyone has a great end to their 2023.